First, I want to say that I appreciate the gentleman from Christian for bringing this bill and the gentleman from McGoffin for this thoughtful amendment. It has a lot of things in it. I spoke with a number of people about this bill and about the amendment. Spoke with some gentlemen from the building industry and was told that it did two things. And when I looked at the bill amendment and read it, does a lot more than two things. I know maybe I misunderstood, but I wanted to say there's a lot of good in this amendment, and my friend from McGoffin has brought that forward. And there's some things in this amendment that I support, and hopefully, as we go through the process, we can have further discussions about that. But this is a process. This bill will go over to the Senate if it passes the House, and there's more opportunities to improve it. But while I like a lot of things in the amendment, there are three things that go too far, in my view, with all due respect to my very good friend from McGoffin. The first thing is, on page 2, line 26, the floor amendment would remove the ability for the aggrieved party who wins in court to get attorney's fees. So if you're a business and you've been harmed and then you go to circuit court, you should be able to get attorney's fees and costs for that. OSHA allows that in the Equal Access to Justice Act, and many states that are doing what my friend from Christian County is wanting to do here and make the state consistent with the federal law, they also allowed it, including Indiana. I know that. I'm an Indiana lawyer. I looked that up as well. So the removal of attorney's fees for a business that proves that it was done wrong, I think is a step a little bit too far and a reason to vote no. Another reason is this amendment would remove provisions on page 3, line 8, and 3, line 11 that say that if the employee is going to have somebody stand with them, which they ought to have somebody be able to stand with them in these reviews and these investigations. But the gentleman from Christian had in his bill that person had to be a qualified representative. And that's defined in the bill, and it's someone with the appropriate scientific knowledge or experience and so forth to be helpful and to know what's going on in the review. The floor amendment removes the responsibility, the requirement to be a qualified. That's right. Maybe we're in the 100-acre woods. I don't know. The floor amendment removes the responsibility, the requirement that it be a qualified representative. So it could be any representative. Conceivably, it could be a child, a spouse, a neighbor, someone that doesn't necessarily know anything about the situation. I think that goes a step too far and gives us another reason to vote no on this floor amendment while communications continue on the bill. The other thing that it removes is my friend, the gentleman from Christian, in the bill, underlying bill, on page 4, line 27, removes all appropriate relief. And then, so what that means is, what the floor amendment would do would allow the circuit court to do anything that it wanted to do as long as it thought it was appropriate. What the bill does is it outlines the things that can be done. I don't think we should allow the cabinet to make the decision on what it thinks is appropriate. We're trying to outline those kinds of things rather than leave it open-ended. Again, some of the things in this amendment I think are good. I want to be involved in the communications that are ongoing, hopefully that continue in the Senate. I've already talked to a number of senators about doing so. I'm wrapping up. If the gods would allow. There's not gods. It's not. I didn't mean to be plural. There's only one. But I would say that this is too far, this amendment. There's a reason to vote no and to allow the communication to go forward. There's some good things to it, but it just goes too far for at least the three reasons that I've outlined. I ask everyone to vote no on the floor amendment. Thank you.